Legally Speaking, with me, Tarun Nangia, in our continuing series on the Prevention of Money Laundering Act with Mr. Karnail Singh, who's managing partner of law firm Circle of Counsels. We will again discuss today some recent developments of PMLA. In light of it, what is that the litigants, the people at large should know about PMLA? He will inform and educate us on that front, also highlight certain investigating truths which everybody ought to know. And we will discuss with him today more on this. Good to see you, sir, and thank you so much for your time. So at the outset, I want to ask you, recently some cases have happened, and in light of those cases, the law has also progressed. Could you share with us some investigated related aspects of PMLA in light of recent developments, which every promoter or businessman ought to know?
The most important case is the understanding of money laundering. The money laundering basically is defined the conversion of ill-gotten money to the legitimate money. Now, what is ill-gotten money? The money could be the black money, which is the tax evasion money, or it could be the crime money. But as far as the PMLA Act is concerned, even all the crimes are not included in the money laundering process. The black money is not part, number one, for the money laundering process as per PMLA Act. Basically, what PMLA Act does is it has 3 schedules, which almost everybody knows about them. And in these 3 schedules, there are around 30 acts consisting of 160 sections of these. If there is any case registered by any other agency, not the Enforcement Directorate, but other agency, and they're investigating under these offenses, any of these offenses which are in the schedules, we call them schedule offenses or predicate offenses. And the other agencies is called schedule agency or predicate agency, which is investigating the case. For example, there is a case of bank fraud. Now, bank fraud case is which comes under the case of cheating. Cheating comes under the schedule of PMLA Act. Therefore, it becomes predicate offense. Now, if this case is investigated by Central Bureau of Investigation, then CBI becomes the predicate agency. And Enforcement Directorate becomes the agency to deal with the Money Laundering Act, PMLA Act. The predicate of agency's role is to find out whether predicate offense has taken place or not place. And if the predicate offense has taken place, is there any generation of proceeds of crime? Now, the role of ED was that there is a generation of proceeds of crime, which is the responsibility and the duty of the predicate agency to find out. The Enforcement Directorate find out whether these proceeds they have been show that it is the legitimate. So conversion of ill-gotten money or the schedule offenses generation money to the white money is a role of Enforcement Directorate.
So proceeds of crime is not PML?
No, proceeds of crime generation examination is a duty of the predicate agency.
So I want to ask you this question before we move on to arrest and bail. If a promoter siphons out money from his company, it is not PMLA case.
See, if he siphons out money from his company, now siphons out by for example, creating a forged documents, creating a shell companies, for example, he siphons out, then it becomes a case of fraud or cheating against the company. It could be investigated either by serious fraud investigation office because it is an offense against the company, or it could be investigated by the police agencies or CBI. Now, in this case, suppose SFIU investigate this case, SFIU becomes the predicate agency. The role of SFIU is to find out whether there is a fraud or not. And if there is a fraud, how much money has been taken out?
So
ED rules starts after this. That this money which has been generated due to the cheating done by fraud done by the promoter, how this money has been converted into the white money. Now the problem comes is there are boundaries for both predicate agency and the ED. There are boundaries from where they should start their investigation. But sometimes what happens is this boundary becomes blurred. Predicate agency sometimes goes into the area of money laundering also, where the money has ultimately gone. And sometimes ED also starts investigating the predicate offense. Now this one has to understand very clearly, and the concerned agencies have to understand very clearly what are the roles assigned to them by the PMLA Act and the Predicate Act. They should limit themselves within those, because sometimes many of the cases falls because of, or in recent times, in many cases, there are judgments where they say that since there is no predicate offense, there is no money laundering offense, and it is a judgment of Madan Lal case. Supreme Court has clearly defined it. So if they remain in their respective jurisdictions, respective areas of investigations, then such type of things will not happen, that the predicate offense has not taken place, the ED has attached the property. Sometimes that takes place and the courts comes out with the judgment that the case should be closed and all that.
I want to know from you if you can advise, are there any compliances that the promoters are required to do to stay clear of PMLA cases, or there is nothing compliance by PMLA? I'm not saying that you share with us the compliances, because that would be, lot of, you'll have to talk for a lot of time. But are there compliance issues with companies which they don't want to commit an offense, but they get trapped?
See, there can be the compliance issues with the companies. For example, there are companies, the gateway aggregators, for example, they do a process of onboarding. Suppose onboarding is not done properly, or with the connivance of somebody, without proper identification, without proper KYC, suppose onboarding is done. And the person who has been onboarded does the cheating through earning money through or transferring money through that payment aggregator. Then even though payment aggregator may not be involved in the activity, but it will be questioned to find out whether it had connivance or no connivance.
So it comes in the ambit of investigation.
Compliance have to be followed properly. The KYC norms, they should be followed properly.
So companies know it themselves, or they have to be advised on these things?
No, sometimes what happens is there may be the negligence on the part of the companies. So they have to do their compliance structure more stringent so that the negligence is minimized.
And I want to know one more thing before we move to arrest and bail in PMLA. Gaming companies were booked for PMLA cases. Again, compliance issue, you think, on their part?
See, when we see the gaming companies, number one is we are talking about the gambling, online gambling basically.
Yes.
And in some of the cases, the online gambling results into the transfer of money abroad, which also involve the FEMA cases.
Okay.
Gambling per se is not a predicate offense under PMLA. But if somebody takes the money abroad, and it is not disclosed in income tax, that comes under section 37A of the FEMA, and that is also a predicate offense of PMLA. So if in the process of online gaming, the money has been taken abroad, and then ED comes into play in that case.
One thing I want to know from you, gaming companies also have a problem of compliance?
See, certainly, yes, the KYCs are very, very important.
So they have been ill-advised, which lead to this problem?
No, see, here it is, one is the KYC norms, the second is money going abroad, unofficially.
Yes.
So these are the two issues involved in that.
Now we come to the most interesting aspect of PMLA, which is about the arrest and bail. Every promoter is either worried or wants to know, because obviously there have been some prosecutions, and many promoters who have a ECIR on them want to know whether I will be arrested. What does he need to know? What are the recent developments in PMLA, which also he must know?
See, number one is to understand Section 19 of PMLA Act very thoroughly. Section 19 of PMLA, which provides power of arrest to the enforcement directorate officer, is absolutely clear that person would be arrested if the investigating officer has reason to believe that the person is involved, person is guilty of money laundering. And such reason to believe are to be recorded in writing. And these reason of belief or grounds of arrest are to be informed to the person who is arrested. So that is the criteria given here. Now, sometimes what happens is the person is arrested only because on the ground of that he is not cooperating. Now, non-cooperating cannot be the ground for arrest under Section 19, because Section 19 is very clear that there must be evidences available with the investigating officer at the time of arrest, which clearly indicates that person is guilty of the offense. When we say he is guilty of the offense, that means there has to be ample evidences for that. That is number one. Number two is the grounds of arrest are to be informed to the person who is arrested. Now, what is the meaning of inform?
Yes.
Now, many a times what the investigating officer does is he says that I have verbally informed the person what are the grounds of arrest. Now, recently Supreme Court has said the meaning of information. What is the meaning of information? Because there you have to connect Section 19 with Section 45 of PMLA. Section 45 of PMLA says that a person will not be granted bail unless the magistrate is satisfied that case is not made out against him. Now, how the person will defend that case is not made out against him? Unless he knows what are the grounds of arrest. And knowledge then should be in writing, because he has to give it to advocate the grounds of arrest. And person may not remember every grounds of arrest verbally spoken to him. Secondly, what can happen is the person may say before the court that I have not been informed ground of arrest. IO says I have informed him verbally. Now this verbal information becomes a problem. It is the word of the IO against the word of the accused. What is truth? How the court find out the truth in that case? And if you are informing verbally, what is the harm in giving in writing? And therefore, Supreme Court in one of the recent judgment has clearly said that grounds of arrest are to be given to the person who has been arrested so that he can defend himself under Section 45.
So do you think there will be a lot more bails because of this grounds of writing being given?
Yeah, the order basically enjoins upon the investigating officers that they should write properly what are the grounds of arrest. Merely arresting a person because he is not cooperating does not serve the purpose of Section 19.
So one question I have, for example, one person is arrested and reasons to believe in writing are given to him, based on which, say, some lawyer like you or they argue in court saying that these grounds of arrest we don't think are convincing. And the court finds in merit that the ED arrested, but the grounds are not convincing enough for the court also. Then is bail given to him, or the agency has told that you have wrongfully arrested and so there is no arrest at all, you release him immediately?
The court depending upon the stage. Suppose it is a first day when the remand application is put. Then if the court finds the arrest is not legal, in the sense that it is not justifiable, person will be released immediately. But if it is supposed to this has happened, the remand has been given, and then such issues are raised, because of course it becomes late to raise such issues, but the court can grant bail at that stage also. If the court comes to the conclusion that grounds given are not sufficient to indicate or to come to the conclusion that a person is guilty of the money laundering offense.
Okay. So, in the issue of Section 45, which is the twin condition, any developments that have happened in bails regarding to this or the twin conditions, and bail continues to be difficult in PLA, or any recent developments in that?
See, bail continues to be difficult in PMLA because of the twin conditions, and which clearly says that the court, before deciding the bail, has to give opportunity to public prosecutor to represent. That is number one. And number two, the court will grant bail only if court is satisfied that there is no cases made out against the person. Now, such conditions are there in another acts also, because, for example, NDPS Act. For example, Prevention of Unlawful Activities Act. Such conditions are there in other acts also. But since such conditions are there, therefore, the IU has more responsibility to produce before the court the grounds which are justifiable to the court, that these are the justifiable evidences.
One thing businessmen will want to know is the issue of anticipatory bail. Many businessmen will say that, okay, I have a ECIR on me, I want to apply for anticipatory bail, and all evidence is documented. So the agency may summon me for discussing documents or questioning me. Do you think that is the route which is the easy route for many people, that apply for anticipatory bail and then write to the agency that I am available for the questioning and documents are there? I mean, the evidence against me is documented, so maybe my custody is not real. They can appeal to the agency, or do you think that that can simply fail if the agency wants to arrest? The arrest will happen anyways.
See, the anticipatory bail, the person can go to the session court or to the high court, but generally and many times courts gives, if they are satisfied that the case is disputable case, not very clear-cut case against the person, then they give no coercive action sometimes, or sometimes they give the anticipatory bail also, but these are not many cases relating to that the anticipatory bails are given. Very minimal number of cases are there. Generally, in the Prevention of Money Laundering Act, bails are difficult. But if one clubs Section 19 and Section 45, then it becomes important. If one claims that the arrest is a violative of Section 19, because grounds of arrest are not sufficient to justify or coming to the belief that the person is guilty of the money laundering offense, then it is possible to get bail. Otherwise, Section 45 clearly creates an embargo to the judiciary that in such cases of PMLA, unless court is satisfied that no offense is made out, bail should not be granted.
So anticipatory bail is not that easy, you're saying? It is not an easy thing to get.
Yeah, it is not as easy.
Okay. Now, one advice that you would like to give companies who have a lot of cross-border transactions, where money comes in the country and out of the country. Do you think the compliance burden on them has become higher in view of recent cases?
No, I would not say that compliance burden is higher, because they are supposed to maintain the records. Even otherwise, what they are importing, what they are exporting, they have to produce those documents before the customs authority, as well as before the banks for clearing the amount to be paid. Only problem comes is when there's a violation. Suppose somebody is doing over invoice, under voice, import or export, and there is a case under customs. In that case, there is a FEMA violation also, and there could be a money laundering PMLA violations also.
I also, one thing which I would want to know, see, if promoters are booked in cases, do you think that they are also arrested because they don't answer questions properly?
See, this is again a gray area in the sense that the court should show indulgence in this particular thing, because section 19 very clearly says the person should be arrested only when the investigating officer has reason to believe that person is guilty of the offense of money laundering. It is not somebody is not speaking out. It is not that cannot be the ground of arrest, because you say the person is not speaking or person is not giving correct answer. What is the correct answer? In the recent judgment, one of the recent judgments, Supreme Court says, is the correct answer what IO thinks is right? That may not be the correct answer. And secondly, if you go to the section 50, where the statements are recorded. Now, section 50 doesn't differentiate between the accused and the witness. It says anybody has a knowledge can be called by investigating officer to question, and he has, as per section 63 of PMLA, he is supposed to tell the truth. Now, if he doesn't tell the truth, then section 63 provides itself the remedy for that. Now, if you go to CRPC, for example, other cases, in CRPC, the witnesses are called under section 160 CRPC, and their statement is recorded under section 161 CRPC, while the accused statement is recorded under 164 CRPC before a magistrate, judicial magistrate, or in certain cases before a senior officer like SP and above, like Kota, there was a provision for that. Sometimes police also records a disclosure statement of the person, of the accused. Now, so there's a difference totally in CRPC whether the statement is recorded of the witness, he's called as a witness, or he's called as an accused. And when somebody is called an accused, there is a protection provided under Article 20, Part 3, that no person who is an accused of an offense can be compelled to a witness against himself. So there is a protection. If the person is called for in the investigation as an accused, there is a protection to him that he has a right.
He can say no, he can refuse to answer.
Yes, he has a right to be silent. And
he can also say that I don't want to answer.
Yes, absolutely. But if somebody is called as a witness.
As an advisor, as a lawyer, I want to ask you, as a lawyer, if you tell your client, do you think that if you tell your client to reveal information properly, he can be not arrested because the agency feel he is cooperating? With that, prevent his chances of getting arrested?
Let me explain the difference first. What I was talking of CRPC and PMLA. Yeah. So CRPC provides whether accused is called or witness is called. And then accused has a protection under article of the Constitution, 20 Part 3 of the Constitution.
Okay.
In the PMLA, there is no distinction whether the person who has been called as an accused or has been called as a witness.
Okay.
Since his status is not clear, he is supposed to tell the truth. That is one. So the protection which has been provided under Article 20 Part 3 is now debatable. Whether that protection is available to him or not available to him, because his stature is not known. Now, if he doesn't tell the truth, then section 63 comes into play. That he is supposed to tell the truth when somebody is called under interrogation under section 50 But Section 63 provides its own punishment. And therefore, if there is a specific punishment for not telling the truth, on that basis, the person should not be arrested. That he is not telling the truth, or he is concealing something. Because for that, the IU has to do more work, get the evidences against him. Because Section 19 is very clear that there has to be evidences available with the investigating officer, where he has a reason to believe that person is guilty of offense. If person is not replying, that does not mean he is guilty of an offense.
Oh, that's a fair point.
So that is very, very important point, which the advocates should understand.
In fact, this provided me an idea for my next show. I would like to talk to you on interrogation and questioning in PMLA cases. A lot of people would want to know how to answer, what to answer, because as you said that does the witness or the accused have protection or no, it's not known. That is what you said against not revealing.
Witness doesn't have protection. He is supposed to tell the truth.
Yes.
As far as the accused is concerned, Constitution providing protection.
Okay. Thank you for clarifying that. Appreciate your joining us today. You spoke to us on a range of issues, which the promoters, businessmen who engage in this activity, and if they make a mistake, are liable to be prosecuted under PMLA ought to know. It will go a long way in improving awareness among this class of people, the general counsels, the promoters, and the businessmen. Appreciate your joining us. Looking forward to talk to you on the next show, and when we do the next part of our series on the Prevention of Money Laundering Act. Thank you so much for your time.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.